Hello everyone! Our group Ella Fugoso, together with Ma'am Ellen Dapin and Sir Joy Valley, will be presenting a case digest about child abuse. This is a case of Felina Rosaldes, the petitioner, versus People of the Philippines, the respondent. General Register Number 173988, and October 8, 2014 is the date when the decision was made by Bersamin J., the ponente or the writer of the court's majority decision. The petitioner's prayer and the respondent's prayer. The petitioner seeks an acquittal as she did not deliberately inflict the physical injuries suffered by Michael Ryan, and that her act of discipline is under in loco parentes or special parental authority. On the other hand, the respondent's prayer is to uphold the decision of the Court of Appeals, and the decision is that the petitioner shall suffer the indeterminate penalty, which means imprisonment, which will be expounded in the preceding slides.
Here are the facts of the case. Michael Ryan Gonzalez was a 7-year-old grade 1 pupil at Pughanan Elementary School located at the municipality of Lambunao, Iloilo. Felina Rosaldes, the petitioner, was Michael Ryan Gonzalez's teacher. On February 13, 1996, Michael rushed into his class and accidentally hit the knee of Rosaldes, who was asleep. Roused from her sleep, Rosaldes asked Michael to apologize to her, but he did not obey and went to his seat. Then Rosaldes went to Michael and pinched him on his thigh. She held him up by his armpits and pushed him to the floor. As Michael Ryan fell, his body hit a desk and he lost consciousness. Then she picked him up by his ears and repeatedly slammed him down the floor, and Michael cried. After the incident, Rosaldes proceeded to teach her class. During lunch break, Michael Ryan, accompanied by two of his classmates, Luella Loredo and Jonaline Gonzalez, went home crying and told his mother about the incident. His mother and his aunt, Evangeline Gonzalez, reported the incident to their barangay captain, Gonzalo La Rosa, who advised them to have Michael Ryan examined by a doctor. They likewise reported the incident to the police station. On the same day at about 1 p.m., barely 3 hours after Michael sustained his injuries, Michael's aunt and barangay councilman Ernesto Legante brought him to Dr. Ricardo Y. Ladrigo Hospital, where he was examined by Dr. Teresita Castigador. The medical report issued by Dr. Teresita Castigador, first, petechia and tenderness of both external ears, 1 by 2 cm and 1 by 1 cm. Lumbar pains and tenderness at area of L3 to L4. Contusions at left inner thigh, 1 by 1 and 1 by 1 cm. Tenderness and pain on walking, especially at the area of femoral head. The petitioner was criminally charged with child abuse in the Regional Trial Court in Iloilo City, and the case was assigned to Branch 27 of that court. Moreover, the provincial prosecutor of Iloilo, upon approval and directive of the Deputy Ombudsman for Visayas, accused Felina Rosaldes for the crime of violation of child abuse law. On June 26, 2003, the RTC rendered judgment convicting Rosaldes of child abuse and sentenced her to an indeterminate prison term ranging from 4 years, 2 months, and 1 day of prison correctional as minimum to 6 years and 1 day of prison mayor as maximum, and to pay the cost. On May 11, 2005, the CA affirms the conviction of the petitioner with modification that the accused appellant is sentenced to suffer the indeterminate penalty of 4 years, 2 months, and 1 day for prison correctional as the minimum of it, to 10 years and 1 day of prison mayor as the maximum thereof. The maximum length of imprisonment was aggravated because Rosaldes was a public servant, a public teacher. On October 8, 2014, the court affirmed the decision promulgated on May 11, 2005, subject to the modifications that a. the petitioner shall suffer the indeterminate penalty of 4 years, 9 months, and 11 days of prison correctional as minimum, to 7 years, 4 months, and 1 day of prison mayor as the maximum. B. The petitioner shall pay to Michael Ryan Gonzalez 20,000 pesos as moral damages, 20,000 pesos as exemplary damages, and 20,000 pesos as temperate damages, plus interest at the rate of 6% per annum on each item of the civil liability, reckoned from the finality of this decision until full payment. And C. The petitioner shall pay the cost of suit.
Now here are the education-related issues of the case. The first issue is, was the petitioner Felina Rosaldez guilty of child abuse? The court said yes. Supreme Court agrees that Felina Rosaldez was guilty of child abuse, and further emphasized that, although she could duly discipline her pupil, Michael Ryan, her infliction of physical injuries on him was unnecessary, violent, and excessive. The Supreme Court's decision was based on the Family Code Article 233 and Republic Act No. 7610, Section 3B. The Family Code Article 233 states that the person exercising substitute parental authority shall have the same authority over the person of the child as the parent. In no case shall the school administrator, teacher, or individuals engaged in child care exercising special parental authority inflict corporal punishment upon the child. The decision was solidified through the medical certificate issued by Dr. Teresita Castigador, which reveals the following results. Number 1. Round spots that appear on the skin as a result of bleeding and the tenderness of both external ears. Second, lumbar pains and tenderness at area of L3, L4 spinal motion segment. Third, contusions at left inner thigh. And fourth, tenderness and pain on walking, especially at the area of femoral head. The Republic Act 7610, Section 3B, states that child abuse includes psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment. The petitioner was absolutely guilty of child abuse, due to the fact that the child was affected psychologically. The child even wanted to transfer to another school because of fear to his teacher. The second issue is, was the sentence and penalty of Felina Rosaldez appropriate? The court said yes. The Supreme Court upheld that the sentence of imprisonment and penalty for Felina Rosaldez was appropriate. Based on the Republic Act 7610, Section 31E, the penalty provided in the Act shall be imposed in its maximum period if the offender is a public officer or employee. Republic Act No. 7610, Section 10A states that the crime committed by the petitioner with prison mayor in its minimum period, whose 3 periods are 6 years and 1 day, to 6 years and 8 months for the minimum period, 6 years, 8 months, and 1 day to 7 years and 4 months for the medium period, and 7 years, 4 months, and 1 day to 8 years for the maximum period. From Section 2, Rule 120, the court should determine and set the civil liability ex delicto of the accused, in order to do justice to the complaining victims who are always entitled to them. The rules of the court mandates them to do so unless the enforcement of the civil liability by separate actions has been reserved or waived. The Civil Code Article 2230 states that the victim is entitled to exemplary damages if at least one aggravating circumstance attended the commission of the crime. And Civil Code Article 2224 states that when some pecuniary loss has been suffered but its amount cannot be proved with certainty, temperate damages may be applied. The third and the last issue. Was the discipline imposed by Felina Rosaldez within the exercise of special parental authority or in loco parentis? The court's decision was no. Though she is under the special parental authority or in loco parentis doctrine, her acts are unjustifiable, for she inflicted corporal punishment which is violent, unnecessary, and excessive upon the child. The court's decision was supported by the Family Code Article 223. The parents, or, in their absence or incapacity, the individual, entity, or institution exercising parental authority may petition the proper court of the place where the child resides for an order providing for disciplinary measures over the child. However, if in the same proceeding the court finds the petitioner at fault, irrespective of the merits of the petition, or when the circumstances so warrant, the court may also order the deprivation or suspension of parental authority. Though she is a teacher exercising substitute parental authority, she must not inflict corporal punishment upon the child.
As a final point, here's what the Bible tells us about this case. Since the petitioner treats the child where it goes beyond the word discipline, Paul the Apostle in Ephesians 6 verse 4 it says, "Fathers, do not provoke your children to anger, but bring them up in the discipline and instruction of the Lord." Now, fathers and mothers are responsible for the development of character of their children. In becoming the parents of children, they must cooperate with the Lord in educating them in sound principles. And it was seconded in his book in Colossians 3 verse 21, it says, "Fathers, provoke not your children to anger, lest they be discouraged." Since the petitioner was entrusted by the parents, she must render an account and be faithful to the little few committed to the trust that the parents placed on her. And in Proverbs 13 verse 24 it says, "Whoever spares the rod hates his son, but he who loves him is diligent to discipline him." According to a preacher, as an educator and a second parent in a school setting, we must apply redemptive discipline, which means treating those who are committing mistakes, treating erring students the way God treats us as a sinner. Forgive them just as freely as you hope to be forgiven of your Father in heaven. So kindly instruct them and bind them to your hearts. It's actually because we love our children that we discipline them. And Ellen G. White in his book Child Guidance, page 259, it says, "Remember that your children are young in years and experience. In controlling and disciplining them, be firm but kind." So as an educator and a second parent in the school learning environment, we must discipline our students with firmness, but all mixed with love. And that completes our presentation. Thanks for listening.